Mr. Njiru is submitting on, which touches on very critical facts concerning Professor Kindiki as to his qualifications. And we are all familiar with the qualifications of Professor Kindiki.
I think the last time Mr. Kamodho was before you, he said he has no client.
I have a client, the 10th respondent, the United Democratic Alliance. I ceased to act for the other client because it would have been illegal. But I have a client. So I'm properly on record. And it is important that the record be made straight with regard to Professor Kindiki's qualification, and including what had been cited in the affidavit that he was not a member of the UDA for 3 months, which is not a requirement in law. No law requires you to be a member of a political party for 3 months for you to ascend to the position of the deputy president, which Professor Kindiki has acceded to. And secondly, it will be...
That's a merit issue that is being argued. So are we going to have the opportunity to answer it? Because the law is the opposite of what you say.
It was raised by Mr. Njiru. I'm just clarifying, and then Mr. Njiru will continue.
To raise that issue, that is my submission, my law. He is going into the merits.
But then Mr. Njiru may
just let's sort it. My lord, it's me who is on record for Professor Kindiki. I think if Mr. Njiru, my very good friend, I usually call him the Black Bull, could keep off rehashing his application.
The black what?
Bull. That's what Njiru means. If my friend the Black Bull could keep within the remit of a rejoinder and a reply, we will not be having all these interjections. I've been resisting the urge because I always try to avoid appearing cantankerous. But if he keeps rehashing his application, unfortunately, then as the person on record for Professor Kindiki, I will be forced to be cantankerous, which is not my nature.
Let's give Mr. Njiru time to finish. I am also obliged, my lords. My lords, finally, let us distinguish the Kisii case from what is before you. What is before you, my ladies, my lords, is a case where a party was not granted an opportunity to be heard. It is a question where there is a violation of Article 27, violation of Article 10, violation of Article 50, and violation of Article 25, that the right to be heard cannot be derogated. What was in Kisii, my ladies, my lords, is that the Kisii deputy governor underwent the full trial at the Senate. And therefore, my ladies, my lords, those facts are distinguishable. Finally, my ladies, my lords, Mr. Gumbo urged you to fight that there will be crisis if the position of the deputy president is not filled. I want to remind him that Article 139 and Article 146 has created an avenue and a remedy where if the president is even today impeached, the remedy is that the Speaker of the National Assembly under Article 146 takes over for 60 days, and under Article 139, if the two of them are not able to take office, again the remedy is that the Speaker takes over. So we are not in a crisis whatsoever, my ladies, my lords. I invite my learned friend, Senior Mr. Kibe, to proceed.
My Lord, I start with the assurance to my learned colleagues that I know what is reply to issues of law. So I hope I can proceed without a lot of interruptions. My Lord, I start with the submissions by my learned colleagues, Professor Muigai. I agree with him, my Lord, that you cannot be able, we are entitled to a legal opinion, but we are not entitled to a set of facts. And therefore, where the set of facts is as they are. But my Lord, in saying this, it is important to remember that what also litigants are not entitled to, and this is the reason for conservatory orders, is the fact that unlike in war, where you can change facts on the ground, the court looks, the court does not accept a situation in which one party would be allowed to change facts on the ground